Well, it is week 9 in American government, and this week the title of our lesson is, if I can recall, it's a long one, Habeas Corpus Act, the English Bill of Rights, and founding thinkers Montesquieu and Blackstone. So we have a little bit to get through today, along with some fascinating historical context. Last week, the last major historical event we left off with was the English Civil War. And then at the conclusion of the Civil War, the trial of King Charles I for treason. And the first time in history that a people had actually held their king to the law and had convicted him of treason against his own people, King Charles I being beheaded publicly in front of his own palace at Whitehall. We also introduced you to a couple of the thinkers of that period, the philosophers who wrote because of the experiences that they'd had, particularly Samuel Rutherford, who's going to give us just really important articulations of biblical resistance theories. What is the source of the law? What are the source of your rights? What is the proper way to walk through resisting a tyranny in civil government? We also looked at the writings of John Locke, and let me check real quick and see if I've missed anybody. So Rutherford and the trial. Oh, and Algernon Sidney, of course. Yes, Sidney, who will wind up a victim of the Restoration King, Charles II. But we haven't quite gotten there. I know I jumped ahead in telling you about Sidney, his writings, again, based on his experience with the English Civil War, the importance of voluntary consent, of the king being under the law, of representation, again, writing beautifully and brilliantly, ideas that our founders are going to be feeding on. Because, guys, this doesn't happen in a vacuum. It doesn't just happen in England. Remember, you've got all these English colonists who have fled King Charles I, that guy. They fled him. They fled his tyranny and others that had come earlier, and they're very aware of what is happening back at home. So they are reading accounts in their newspapers. Things are being reprinted in the colonies. They're receiving letters from back at home. They're very aware of what's unfolding. The writings of these philosophers are being printed and published, or printed, published, and shipped into the colonies, and our folks are reading those writings as well. All of that is going to lay a very firm foundation, again, ultimately rooted in biblical ideas about man and government, but that will bear fruit when the English colonies face a tyrant civil government later on. Something none of them are anticipating, that again, their own country will turn on them in the future, but this is laying that foundation philosophically. So with that, we can turn to this week's notes. So be sure you have this all printed out and ready to go, beginning with that image of Oliver Cromwell. This week, guys, also be sure you've got your new bookmark. And here on the back, we are right here in the blue section with Charles I. So Charles I being beheaded, and then the interregnum taking place. We'll talk about that a little bit today. The interregnum being the time of parliamentary control and the rule of Oliver Cromwell. And then we'll get into the Restoration and moving forward. All right, so make sure you've got that handy just so you've got the dates and can see who lived when. All right, I think, pen and highlighter as always. Let's get right to it. So again, rewinding ourselves just a little bit, after the execution of Charles I in 1649, England will be declared what's called a commonwealth, that they are no longer a monarchy. This is revolutionary as well, and it's not going to last. They are a commonwealth briefly. Being a commonwealth meant that they were declaring themselves to be a republic where governance would literally be by the representatives of the people. And guys, who were those representatives of the people? In what body did they govern? Parliament. So Parliament was now in control, not a monarch. There was no, the executive would have been Oliver Cromwell, but there was no monarch. So governance was by Parliament through the representatives of the people. But that form would fail pretty quickly because those loyal to the monarchy continued to raise opposition to parliamentary rule, and not only did they raise political opposition, but they were able to raise armies as well. And so fighting for survival Parliament will eventually have to do what normally happens, turn to a strong man, a strong leader, and that leader will be Oliver Cromwell. So he will be named Lord Protector of the Commonwealth, but he's granted extreme powers, so he's able to dissolve Parliament at his will, kind of more powers than they'd ever wanted a monarch to have. They're now granting to Oliver Cromwell. He's also granted rule for life, so essentially he's like dictator for life, and at his death, the reins of power will be passed directly to his son. So what they had sought to avoid, right, a hereditary monarchy, they're now almost recreating with Cromwell. So the military leadership of Oliver Cromwell became necessary in this moment. He's declared Lord Protector of England, granted rule for life, and given great powers over Parliament. And this should just speak to the fact, you guys, it's so hard to find that balance on the teeter-totter. That although they wanted to throw off the tyranny of King Charles I, that as they're trying to establish, liberty with law, that it requires a great deal of self-government. And in this case, you did not have a united England that all wanted the same thing. You still had a big portion of England that wasn't ready to govern in that way. So it was just, they were not successful in coming to a place of maintaining that balance. But scholars will tell you, like, this is laying the foundation for something that will come in the future, where England will reach more of that balance between liberty and law. As I mentioned, at Cromwell's death, his son ruled briefly but ineffectively, and out of that political confusion, the people will cry out for something that they know. So they will cry out for a return to monarchy. Now, they don't want another tyrant. They, of course, vividly remember the tyranny of King Charles I, right? But they invite his two sons to return from exile in Europe, and here's an image of the two sons, Charles II and his younger brother, James II. Charles is the eldest. He's named after his father, and so Charles II will become King of England in 1660. That 11-year period of parliamentary Cromwellian rule becomes known as the interregnum, Latin words meaning between reigns. So a time in England where there was no king, between Charles I and Charles II, and you see that on your bookmark as well. Charles II now gets a nickname, if you will. He becomes known as the Restoration King because it's the restoration of the monarchy. And he has a fairly long reign, 25 years. Now, sadly, you guys, you would think he'd learned the lesson of his father and that he would have completely abandoned any thought of the divine right of kings. That's not what he thinks. He thinks they're desperate. They'll do whatever I want, and I'm going to assert every right that I possibly can. He's a full-on believer in divine right of kings. He's not quite as bad as his younger brother, but he's not moving us in a good direction, and he's going to lock horns and knock heads with Parliament, with the representatives of the people, over and over again, much like his Stuart father. He, as you recall, is married to a Catholic wife. That had been a big bone of contention back during the reign of Charles I, right? The Puritans in Parliament had been very alarmed when he came to the throne and was betrothing his children, or especially his oldest, the heir to the throne, to a Catholic. They're thinking, how can you do that when this young man is supposed to come to the throne and be the head of the Protestant Church of England? So it was very clear to everybody that Charles I was undermining any kind of effort at biblical reform within the church, which was extremely alarming to Puritans across England, guys, again, who really desired a biblical expression of worship within their churches and teaching and doctrine and all of that. So he comes to the throne, Charles II. We're going to find that he, like his dad, is kind of a slippery creature. He sneaks around. He won't call Parliament. He's negotiating treaties on his own. Particularly, he will negotiate a secret treaty with the French Catholic King Louis XIV. The French are not usually our friends, but he will negotiate this treaty, and he negotiates it against, going to war against, the Dutch Protestants. And that nation had traditionally been an ally of England. And so this does not go over well with the people of England. Let me fill in some blanks for you. Secret treaties He also, yes, proclaimed edicts of religious toleration, which sounds great on the surface until you realize that what he wanted to tolerate were more Catholic beliefs coming into the church and really eliminating any kind of Puritan Protestant reforms. We were drifting in the wrong direction according to English Protestants, and he clearly does not want to see anything returning to Reformed belief and doctrine. So it was designed to force reforms out of the Church of England. Now, something that he'll become known for as Restoration King, during his 25-year reign, we see more colonies planted in North America, more English colonies planted than under the reign of any other monarch. So I want to go over our 13 English colonies with you really quickly, just to get that in your brain, and then talk about the ones that were planted during Charles II's reign. So just as a reminder of where the first colonies came from, right? In 1607, Virginia will be planted. But Virginia is most of North America. Do you remember the map? I mean, it's almost everything. But it's planted. Virginia is established at Jamestown, so right in here. And the king at the time, of course, is James I, who is the heir following Elizabeth I. Queen Elizabeth dies with no children. James I, who is James Stewart, will start the new dynasty. So it's under James I that this colony is planted. We know from their charter that they had a missionary focus. Richard Hakluyt writes an incredible document establishing a foothold for England and for Protestantism over and against Spanish Catholic dominance in the New World. 13 years later, we have the colony of Plymouth established. This is still during the reign of James I, and it's largely, again, religiously motivated, right? Because he's not wanting to move more towards Reformed theology and doctrine, but he is moving away from it, so much so that there are groups of people in England that say they can no longer worship within the Church of England in good conscience. And he says, well, if you won't conform to what I'm changing in the church, I'll harry you out of the land. And that's exactly what happens to these people who are called separatists. They'll become known as the Pilgrims. And of course, they'll receive a charter providentially and wind up establishing the colony of Plymouth right here where this little hook is located, where Cape Cod is. Now, on this map that I'm showing you, it shows the 13 colonies as they existed at the time of the American War for Independence. But y'all remember that when Plymouth got there wasn't anything else. It was just Plymouth. 10 years later, many of their Puritan compatriots, people that, again, wanted to see continued reform in the church, recognize after the Petition of Right, after all of the conflict with the king, they see this is not going in a good direction with Charles I, right? And so there are thousands of them that will pack their bags, pack their families, board ships, and head for the New World, head for New England, where they will establish the Massachusetts Bay Colony. So fleeing from the tyranny of Charles I and fleeing from what they see is coming, which is war, and they're right. Okay, so thousands come in the Great Migration to Massachusetts Bay Colony. So this whole yellow section, guys, was almost all Massachusetts Bay, except for this little part out here, this hook, and a part of what says Massachusetts that was Plymouth. And they were two different colonies, Plymouth, Massachusetts Bay. Okay, then 1634. We're not quite to the Civil War yet. And reflective of the religious conflicts that were going on back in England, while the separatists and the Puritans were vastly dissatisfied with King Charles I, and their consciences burdened them, and they felt they could not worship in good conscience in the Church of England because of the changes he made. At the same time, remember that Catholics, there were remaining Catholics in England, and they felt like Charles I wasn't going fast enough back towards Catholicism, and they felt that their consciences were violated. And so as a gift to a favored courtier who was Catholic named Lord Baltimore, Charles I will give a land grant. It's right down here. They carved it out of what was then Virginia. So some land was carved out right here, and it will become Maryland. Okay, it's named after Charles's wife, Mary. So this will become Maryland in 1634. 2 years later, we have two new colonies born out of Massachusetts Bay. So right up here in Massachusetts, if you'll remember, it's Reverend Hooker who leads 100 settlers out into Hartford, out into Connecticut. And then it's Reverend Roger Williams that same year who will lead a group of settlers to found Rhode Island. We looked at the fundamental orders of Connecticut. We looked at their oaths. I mean, you guys have seen what their motivations were, the covenant structure of their government, all of the rights of Englishmen preserved, representation, voluntary consent, higher law, honoring God, all those wonderful things that are in those documents. That's what we see reflected up in these emerging New England colonies of Rhode Island, Connecticut, Massachusetts, Plymouth. And they were not quite yet to the other one. So then in 1642, the war breaks out. We have no new colonies during the Civil War. So from 1642 to 51, nothing. Now we have the restoration of the monarchy. 1660, King Charles II, the son, takes the throne. And boom, we suddenly see kind of pent-up energy, perhaps, in heading to the New World and the birth of new colonies. The first one was fairly large, was most of the land that you see here designated as North Carolina, South Carolina, but it was simply called Carolina at that time. And this was a proprietary colony. So we talked about that last week. Proprietary meant it was the property of the people that he granted it to, and they had sole control over the governing structure. I mean, they couldn't do things that were against the law of England, but they were essentially in charge and could set up the governance the way that they wanted to in their colony. So Carolina was granted to 3 loyalists who had helped to bring Charles back to the throne. This was a reward to them. And in his honor, they named the colony, they took a derivative of his Latin name. So Charles in Latin is Carolus. And so this became Carolina in his honor. I put a little note in there for you that Carolina in 1729 will split into North Carolina and South Carolina, and at the same time, almost just a couple years later, authority is transferred out of the hands of these private folks. They transfer it back into the hands of the crown, meaning that the king will now appoint royal governors to rule North Carolina and South Carolina on his behalf. So that's important to note, that they start out proprietary, but they become royal colonies. Then, in 1664, you have a huge jump in landmass, if you will. And that's because, I shouldn't say landmass, but in population and in strategic land that's acquired. And it's acquired due to a treaty. Remember I told you he was sneaking around and going to war against the Netherlands, and the people didn't like that very much. But at one point, when he's winning the war, part of the peace negotiation involved transferring colonial holdings that the Netherlands had. And so New Amsterdam was New York, and New Sweden had allied with the Netherlands, and I can't remember the third. But anyway, now they will become known as New York, New Jersey, and Delaware. So those 3 colonies, New York, New Jersey, and Delaware, are transferred by treaty from the Dutch and the Swedes after Charles II wins a war against them back at home. So they will all become English colonies in 1664. Now, guys, if you go and look for, if you Google search for, when did New York become a colony, it's going to have a much earlier date because it was first a colony of the Netherlands, but it transfers into English hands in 1664 during the reign of our Restoration King, Charles II. Then in 1679, New Hampshire forms, and New Hampshire just really becomes legal in 1679. They've really been operating separate from Massachusetts Bay. They're another one that's carved out of the land holdings of Massachusetts Bay. They had considered themselves separate for decades, but Charles II is the first to recognize them as a separate colony. So New Hampshire we see in 1679. Then he will grant another proprietary colony here, to a man named William Penn. So this is a sole proprietorship. One man is granted this huge chunk of land, and it's named after himself. Penn's Forest, Pennsylvania, is formed in 1681, still while Charles II is on the throne. So as you can see, we have an explosion of English colonial activity during the reign of our Restoration King. we've covered all of them now, all of the colonies except one. And it won't come for many more years, not until 1732. Under the reign of King George II, there was land down here to the south that was disputed between Spain and the English. And so the English will come in and they will form this colony primarily to serve as a buffer zone between, y'all know what's south of that because you live there, Florida. So Florida at that time was divided into East and West, and it was controlled by Spain, East Florida, West Florida. So they had two colonies sitting there. And this was to provide, again, some buffer between the enemy and the other 12 colonies. So Georgia founded in 1732 for that purpose. Oh, and named after the king at the time, who was George II, hence Georgia. I don't know about you, but I think it's fun to know the origins of these city names and state names. But that brings us to our next little piece of legislation, our next document. And we're not going to read the document, so I'll just explain it to you. It's called the Habeas Corpus Act of 1679. I mentioned that our Charles II is a bit of a slippery creature, and he begins to take up some of the activities of his father. And he'll arrest those that are political enemies and simply throw them in prison and begin to move them from place to place so that their families really aren't sure where they are or how to advocate for them. He's sometimes holding them for months before even bringing them to a trial when, yes, perhaps a justice finds that there was no lawful reason to hold this person. But in the meantime, they've lost property, they've lost liberty, they've lost time, they've suffered many times by being imprisoned unfairly for months. So in 1679, Parliament will pass the Habeas Corpus Act. And of course, Charles II is on the throne. So that will be your blank right there. And I think I've already explained this. And yes, what they're doing with the Habeas Corpus Act is not inventing, not that you would invent a right, but they are not even laying out or explaining any new right that hasn't been explained before. What this really is a rehashing of Article 39 of Magna Carta. But they're just going to get into some details because we need to, because he's not abiding by Article 39 of Magna Carta. So they kind of did that in Petition of Right, if you recall, that they took Article 39, they took Articles 28 and 30 that talked about not being able to steal people's property. You couldn't take their carts and their wood for your castle and all that kind of thing. And they applied that idea of not taking people's property without parliamentary consent. They took it and they applied that to no forced loans and no quartering of troops because you're taking people's property. So y'all follow? It's not a new right. We're just kind of we got to apply it now to this current situation that we're dealing with. So Magna Carta was about the king not being able to thieve from his people. Petition of Right was about Charles I not being able to thieve from his people. And Habeas Corpus Act of 1679 is now about Charles II not being able to abuse the judicial rights, the rights to life, liberty, and property without lawful juries and lawful trials. So they're just going to spell it out a little more clearly in the law. And here's what they said. Well, here's where they based it. They get this. They root it in Magna Carta, Article 39. No free man shall be seized or imprisoned, or stripped of his rights or his possessions, or outlawed or exiled, or deprived of his standing in any other way, except by the lawful judgment of his equals or by the law of the land. So none of those things can happen to you. No seizing, imprisoning, taking your stuff, outlawed, exiled, any of that, unless you've had a trial by jury, judgment of your equals, and it's a lawful trial, or by the law of the land. This is simply defining, well, then what's lawful? What does that look like specifically? Now, habeas corpus is a Latin term that means you have the body, the corpus, like the corpse. Yes, you have the body. So it clarifies that when someone is arrested, there have to be certain things in place so that we know who has the body, where is the person, what's happening to them. The first important idea that we see is that of higher law. That law, we have to respect lawful boundaries. So prisoners have the right to demand that a court examine the lawfulness of their detention in order to prevent false imprisonment or unlawful imprisonment. So today, guys, we would call this an arraignment, or you've seen it on television. They had their first appearance before a judge. Well, that's when we make sure that this is a lawful arrest. Okay, so we're going to talk about the time frame in a moment, but first of all, it guaranteed that a person is going to be seen by a judge and presented with the evidence against them, and that this is a duly it is a proper arrest, and that it is lawful that this person be examined. So that's the first guarantee in Habeas Corpus Act. The next thing is we want to protect their liberty, their ability to move about as they should. So if someone's arrested, then there is a specific limitation on the time that can pass and the conditions under which prisoners had to be brought before the courts. So you can't just grab somebody and say, well, we'll determine if it's lawful in a couple months. No, there was a specific time limit now placed on when the government had to bring those charges and place you in front of a judge. We see the idea of equal justice, that everybody has to be treated the same. Jailers cannot be moving prisoners, particularly those that have offended the king, might be moved from place to place, so it made it very difficult for the family or a lawyer to advocate on behalf of this person if they didn't even know where they were. So no jailers can move the prisoners from one place to another, and you can only hold them for a certain number of days before we can also say this was liberty, has to do with their liberty, because only a certain number of days can pass before bail is offered, where you have to be given the opportunity to be bailed out. And finally, this is pretty important. I highlight this because this act had some teeth. If the king's government violated this act, if they violated any of these specific provisions in the course of arresting you and bringing you to trial, then the prisoner could essentially sue the government, and fines were to be paid to the prisoner if the act was violated. So it provided for damages. Again, you can write any of this in the margins if you want, but damages or fines would be paid to the offended prisoner if the act was violated. So that's the Habeas Corpus Act. Now, a little more historical context on Charles II. Down here. There continues to be, guys, this struggle over issues of religion. And we talked about why last week, so I will not belabor that point again, but it's because the head of the church is also the head of state. And so the sword is being used to enforce religious doctrine and belief. So this continues to be a very real issue, even though we just fought a war over this. And Charles II is moving us in a clearly more Catholic direction. So the struggle is real. And Charles II, as I mentioned, is a slippery creature. He sought to undo Protestant reforms that had come. He wanted to move more and more towards Catholicism. It became very clear. He and his brother was openly professing Catholic. And he was next in line for the throne of the throne of England, which made him the head of the Protestant church. So what could people anticipate, right? There was desperation again at this point, but they'd asked for it. So slippery creature sought to undo Protestant reforms and to subvert Parliament. Yes, he will not call Parliament into session, much like his father. He's making secret treaties with French Catholic king, goes to war against the Protestant Netherlands, who had always been our ally. Now, Charles will never produce any legitimate heirs. He has lots of children, but none with his wife. So it becomes clear to everybody that we have a problem on our hands, because it's looking like if Charles passes away, it's definitely going to be his brother coming to the throne next, and what kind of damage might he do? Well, it is a struggle back and forth. There are moments where Charles II needs Parliament's favor more than others, and in one of those moments where he really needed their support, he agrees to a compromise, and that compromise is he commits his niece. So James II has a daughter named Mary, no boys at this point. He has a daughter, and she is third in line now for the throne. Well, I guess second after James. So Charles is on the throne, James will be next. His daughter is the next in line for the throne. And so the parliamentary forces reach a compromise with the king that says little Mary will be somewhat sequestered away from her family and she will be raised as a Protestant. And she is. And she is legitimately and truly convicted in her heart that that is the truth. And so she is raised in a Protestant environment. She's trained in all the things that she needs to know to be a future queen. But also in the midst of all of this political chaos under Charles II, during the time that he's at war with the Netherlands, there comes a place in time where he needs to get back in good standing with the Netherlands. There's been a lot of pressure from the English people. They objected to his war against the Netherlands. And so there comes a place in time where in order to restore that relationship with the Protestant Netherlands, he decides, well, there's no better way than to unite the two nations again by a marriage. And so he betroths his niece. After all, she's a true Protestant. So he betroths his niece, Mary, to a Protestant prince. That Protestant prince is not just a prince that hangs around the castle and does nothing. This prince is a warrior prince, and he's been fighting for the religious freedom of his people against the Spanish, against the English. This guy has what it takes. And so she's betrothed to this young man. His name is William of Orange. Let me fill in some blanks here. So the wars have been against the Dutch. His niece will now be betrothed to William of Orange. And I called him a warrior prince because I just want you to get the point that this is, again, not some little weakling that's hanging around the castle and, dining at banquets and jousting with his buddies. So he's out there on the front lines fighting for his people and has been. So she will now travel across the English Channel. She'll join him there in the Netherlands, and they begin their reign together there shortly thereafter. In 1685, so that is 8 years later, kidney failure will take the life of her Uncle Charles. Charles II now dies in 1685, bringing this feared brother, James II, to the throne. If you recall, last week we talked about the death of Algernon Sidney because he had been so opposed to James II coming to the throne. He had supported a different candidate. He'd actually supported one of the illegitimate children of Charles II. You don't need to know all that. It's all such drama, such a soap opera. But it's also so Algernon Sidney will lose his head over this, and they convict him on the basis of his writings. They say that his writings, reveal that he doesn't support the new king. Well, he didn't support the new king, but I don't think he actually committed treason against James II. And Sidney famously said that we live in an era when truth passes for treason. John Locke is also forced to go into exile at this time. He fears what might happen to himself. Predictably, James II, as everybody knew, was going to be his brother on steroids, and that's exactly what happened. So he increases royal authority. He returns the Church of England to many Roman Catholic practices. He ignores all of the limitations of law. He is his father's son. In the colonies, he is a tyrant as well, and he becomes a hated name in the colonies. He is going to revoke the independent charters of New Hampshire, Massachusetts, Plymouth, Connecticut, Rhode Island, New York, and New Jersey. He doesn't like the idea that these guys have separate charters, that they have self-governing representative assemblies, that they really have been doing this now for years, for about 70 years at this point. And he doesn't like that. He wants them to be under total royal control. Top down, I'm in charge, I'll send my royal governor. And that's just what he does. He sends a man named Edmund Andros, who also becomes quite hated in New England. And Andros goes from colony to colony, actually trying to collect the physical charter that belonged to each of these. Y'all remember how the people of Massachusetts Bay prized that piece of paper? They brought it with them and that they still have it today. Now, I don't know the story of how their charter was preserved, but in Connecticut, same thing. They prized that charter, the actual piece of paper that they had. And that charter, when Andros came around to collect their charter, they agreed to a meeting. They all gathered in this building, and just as the paper was supposed to be presented to him, with all candles at the time and lanterns, but suddenly somebody gave a signal and all the lights went out in the whole building. And in the dark, it took a minute to get lights, and when they did, the charter was gone. And so we don't know exactly who took it, but it was preserved in an oak tree. It was hidden in the hollow of an oak tree so that the king's officials could not get their hands on it. And the people of Connecticut are very proud of that tradition of defending their liberties and their rights as Englishmen over and against the tyranny of King James II. So much so that if you ever find a Connecticut quarter, here, let me get to it. I'll show you the picture. Let's fill in your blanks. Royal colony. He wanted to form a royal colony called the Dominion of New England that he would control. Remember, this is like going up against the Scots and the Picts, okay? These were fiercely independent people that had sacrificed everything to get away from the tyranny of his father. And now here he comes. So yeah, not going to go over very well. And Connecticut famously hid their charter in an oak tree to keep it from being seized. And here's the image of the Connecticut quarter. So if you look close, you'll see the charter oak. The charter oak, of course, is gone today, but as it aged and it began to decay, the wood was harvested, and I'd have to look up, but I think like the governor's desk in Connecticut is made from wood that came from the charter oak. Anyway, there's some very significant pieces of furniture in Connecticut that are made in memory of this event at the charter oak. Now, long story made short, King James II will pursue many actions seen as intolerable by Parliament. He will not respond to their petitions. They start back through the process like they had done, years before. What would it be now? 30 years before with his father. The people of England who are represented by Parliament recognize we have a problem. We've really made a mistake here, and we don't want another war. But they're faced with a crisis of conscience. Is it worth going to war over? They eventually decide it is. And so at this point, they know that they are at a real decision point between liberty and tyranny once again. So what the decision of Parliament is to reach out to this warrior prince of the Netherlands because, remember, Mary is a legitimate heir to the English throne. She's a Protestant, and she is married to a strong Protestant with an army at his disposal. So they reach out to William of Orange and Mary and invite them to come and take the throne of England. Once James II finds out about this, he kind of puts his feelers out there. He wants to see if he can get, enough royalist support to defend his claim to the throne, and very quickly finds out that he doesn't have support this time around, and he is forced into exile in France. So he will step down from the throne in favor of his own Protestant daughter. Guys, do y'all see the providence in all this? It's amazing. And here come William and Mary to the throne of England in 1688. They arrive in England in 1688. It's called the Bloodless Revolution. William comes with an army, but he is not forced to use that army. The people of England welcome them, but they welcome them with conditions. So even though they are trusting in the motivations and the belief of Mary and William, her husband, they want this laid out in law. So Parliament this time around, they are not messing around. And guys, we have to mark this moment in English legal history, which we will, by looking at a couple of the documents that now come into being. So Parliament, doing everything in its power to prevent any future wars and crises, drafted two documents, the English Bill of Rights and the Act of Toleration. And the acceptance, the signatures on those documents will become the condition for William III and Mary II taking the English throne. So, the English Bill of Rights of 1689. Who's on the throne? Well, William and Mary. And I've given you some excerpts from the document below, but obviously I've edited them to keep it down to a manageable size and manageable reading. And what I really want us to look for in just a moment are ideas that you've heard before, okay? Because again, we're not inventing anything new. It's the English people continually going back to the roots of their law, which you guys know, right? We've rehearsed this over and over again, that ultimately it's biblical roots that were put into print by King Alfred in his Alfredian Code, that were then affirmed by Magna Carta, that were then affirmed once again by petition of right and many other English laws, affirmed by Habeas Corpus of 1679, and that's what we'll see them doing again, drawing back on that rich, unchanging heritage of English law. It's rooted in something that doesn't change, and so they keep going back to it, and that's an important example from which we can learn. So before we get into the actual document, I want to remind you of what was said in Magna Carta. So you guys should have a chart like this that you created, where we looked at the fact that civil government has no claim on your conscience, that there's an idea of religious liberty, a seed of it that was back in Magna Carta. So in Article 1 Magna Carta, we've confirmed for us and our heirs in perpetuity that the English church shall be free and shall have its rights undiminished and its liberties unimpaired. So this was the beginning of the idea of the church being a separate sphere. It doesn't quite work out right perfectly in England, but we see the seed of the idea expressed in Magna Carta. The idea of private property being protected, and that it can't be taken without your consent, even by a king, otherwise it's stealing. We saw that in Article 12, no taxing, so no scutage or aid, may be levied in our kingdom without consent. I can't take your money till I get your permission. No constable or royal official can take your corn or your movable goods without payment. We can't take your horses or your carts. We can't take wood for our castle without the consent of the owner. All these, and that's Article 28, Article 30, and Article 31. 28, 30, and 31 are all property rights. Okay? No corn, no horses, no wood. Okay? And then Article 39, which we've already covered, but again, that's the protection of the individual's person and his liberty and his property. His life, his liberty, and his property can't be touched except by the lawful judgment of his equals or by the law of the land. The idea of taxation only happening through your representatives is in Articles 12 and 14 of Magna Carta, right? You guys looked at this. No scutage or aid may be levied without its general consent within our kingdom without its general consent. Then 14 says, how do we get that general consent? Well, we do it through the archbishops, bishops, abbots, earls, and greater barons, which is Parliament. The representatives of the people have to be summoned. I won't cover this one because we're not going to draw on that. Equal justice under the law. Ordinary lawsuits shall not follow the court around. Y'all remember? Right? That you're not supposed to move the court from place to place. Kind of the same idea that was expressed in Habeas Corpus. In order to be fair, the trial needs to take place locally. Article 38, you can't place a man on trial on your own unsupported statement. You have to have credible witnesses, 2 or 3, to the truth of it. That's rooted in the law in Deuteronomy. Article 39 again. Article 40 is about to no one will we sell, to no one deny or delay right or justice. We see that echoed in Habeas Corpus. We see it echoed in Petition of Right. This is more about jury trials, and I think we've covered all of that. Let's see what else we have. Article 39. Down here, your punishment must fit the crime. You can't have excessive punishments. For a trivial offense, a free man shall be fined only in proportion to the degree of his offense, and for a serious offense correspondingly. So the punishment must fit the crime. If it's trivial, you shouldn't be, taking their entire farm from them. Perhaps a small fine for a trivial offense. And then finally, Article 61 placed the king under the law. If we transgress any of the articles of this peace or security, then you come to us and petition us. If we don't make it right, then you can distrain upon and assail us in every way possible, with the support of the whole community, but again, led by the lower magistrates. So that's a review quickly of Magna Carta, because we're going to start seeing Magna Carta expressed in the Bill of Rights of 1689. Reminding you too about the Petition of Right of 1628. Do y'all remember that they're calling back on Magna Carta and saying by authority of Parliament, down here, by other laws of this realm, all these things, that people may not be compelled to contribute to any tax or tallage or aid that is not set by common consent in Parliament. So they're looking right back to Articles 12 and 14 of Magna Carta in that moment. This is petition of right. It's declared and enacted, no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, except by the lawful judgment of his equals or by the law of the land. Again, looking back to Magna Carta, to protect life and liberty and property of Englishmen. In Article 4, they're reminding once again, it's declared and enacted that no man can be put out of his lands, his property. He can't be taken, he can't be imprisoned, he can't be disinherited or put to death without being brought to answer by a due process of law, by a lawful trial. Article 6 was about you can't put these soldiers into our homes because it's against the laws and customs of this realm. It violates Articles 28, 30, and 31 about not taking our corn and our wood and our movable goods and all that. You're taking our stuff without our consent by putting these soldiers in our homes. And of course, we'll skip to Article 10 of the Petition of Right, which really sums it all up. Article 10 of the Petition of Right just says, no man can be compelled to make a gift, a loan, a benevolence, a tax, or any charge without common consent by Parliament. Article 10 also says, none can be called to make answer or be confined to prison or molested concerning the same, or for refusal thereof. Number 3, your majesty should remove the soldiers and mariners, right? Can't do that. No quartering of troops. And finally, the commissions for military law must be revoked and annulled. Okay, thank you for bearing with me while we reviewed that a little bit, because now I hope it's going to be fresh in your mind. You'll go, oh, I've heard that before, as we look at the Bill of Rights. So here's what the Bill of Rights of 1689 says. This is what Parliament presents to William and Mary as I'm picturing it, but as they come into London and take up residence in their palace, Parliament is going to present them with this document. And it says, whereas the Lords spiritual and temporal and the Commons, so guys, the Lords, that's the House of Lords. This is the House of Commons. Together they are known as Parliament. Whereas the Lords spiritual and temporal and Commons assembled at Westminster lawfully, fully, and freely representing, I would highlight that, all the estates of the people of this realm. So we represent the people. We did present unto their majesties, called and known by the names and style of William and Mary, Prince and Princess of Orange, a certain declaration in writing made by the said Lords and Commons in the words following. So we presented to them the following words. Whereas the late King James II, is he dead? He's not, but in their eyes, he may as well be. Okay, he's gone. He is the late king, no longer the king. The late King James II, by the assistance of diverse evil counselors, judges, and ministers employed by him, did endeavor to subvert and extirpate, so he tried to go under and get rid of, the Protestant religion and the laws and liberties of this kingdom. What did the late King James II attack? The two most prized things in the eyes of an Englishman, his faith and his freedom. I would write that in. His faith and his freedom. The Protestant religion, and the laws and liberties of this kingdom. Here's how he did it. And guys, this used to be an exercise that I did for homework with you. And so y'all bear with me because I spared you that. I'm going to do it with you. And I've given you the answers here. So I used to have you go dig and figure out which articles they were citing. But here he said he's assumed and exercised a power of dispensing with and suspending the laws and the execution of laws without consent of Parliament. Which things did he break in the past? Well, Magna Carta Article 12 and 14 say you have to call Parliament together and get their consent. So he has dispensed with that. He's broken that commitment to the law. He also violated, therefore, Petition of Right, Article 10, by not calling together Parliament. He imprisoned and prosecuted worthy pastors for humbly petitioning to be excused from concurring to his illegally assumed power. Well, here we see a reference to Article 1, allowing some freedom for the Church of England, but there's none there. Articles 39 and 40, which have to do with legal trials and imprisonment. Well, he's ignored that. Petition of Right, 3, 4, 7, and 10 violations. You don't have to go back and look all this up, and I'm not even going to keep reading them, but just see that they're there. And guys, honestly, this may come in handy sometime in the future. You may have an assignment where you can use this, where I've already given you the answers to where did these ideas come from, because we're going to see these same ideas ultimately expressed in our Bill of Rights. The United States of America's documents are rooted in these same things. If you ever have to trace it back to the English Bill of Rights, and then I've given you where to trace it from there. All right. He's erected a new court called the Court of Commissions for Ecclesiastical Causes, meaning a special court to try things that have to do with church violations. You can't just erect a new court because that violates Magna Carta Article 39 and 40. He's levied money for the use of the crown for other manners than were granted by Parliament. Well, then he's violated 12 and 14 again. He's raised and kept a standing army within this kingdom in time of peace without consent of Parliament. Guys, this is a specification. We hadn't actually seen these words before. We'd seen that you couldn't quarter troops. This goes a little further and says he's not to be raising and keeping a army that's just standing here. A standing army means that they're being paid for and supported at all times, even when there's no war going on. That's a standing army, ready. They're ready to go. Well, that was not legal at the time. So I would highlight that. He's raised and kept a standing army within this kingdom in time of peace. Why does he have all these soldiers? Why does he need to have, well, it's to control his people. That's why they didn't like this idea of a standing army. He's also quartered soldiers, contrary to law. I would highlight that. Number 6, he's caused several good subjects that were Protestants to be disarmed at a time when papists, meaning Roman Catholics within the kingdom, were armed. So he disarmed, he took weapons away from the Protestants while allowing the Catholics to have them. And that, of course, alarmed them. So this right to bear arms is going to be born out of the Article 6 of the Bill of Rights, the English Bill of Rights. By violating the freedom of election to members to serve in Parliament, so he does not allow elections to proceed as they should, violating Magna Carta, several Magna Carta articles, including 61, by prosecution in the Court of King's Bench for matters that were knowable only in Parliament. So basically he's using various illegal court procedures, so we know those are violations. Corrupt and unqualified persons have served as jurors in trials for high treason, men which were not freeholders, and you had to be in order to be a juror. So he's using people that he desires to serve on juries. Excessive bail has been required of persons that were committed in criminal cases, people that have been arrested. They're requiring so much bail that they can't get out. Well, that violates Magna Carta Article 20, 21. It violates Habeas Corpus Act. Excessive fines have been imposed. Illegal and cruel punishments have been inflicted by James II. And several fines and forfeitures, meaning seizures of people's property, have been made before they were even convicted. That's an Article 39 violation. Clearly, straight out. It says you can't do that. You can't deprive them of any of their property unless they've been subjected to a lawful trial or by the law of the land. So again, another violation. So y'all see 12 specific violations of English law that they are pointing the finger at James II, her father. Okay, he has done all of these things. And this is their language, all of which are utterly and directly contrary to the known laws and statutes and freedoms of this realm. I would highlight that because, like we did with Petition of Right, the English people are always going to go back to the law. They're going to cite the law that has come before, and that's what they are building on. Why can they do that? Because it's rooted in something unchanging. And thereupon, they say, the said lords, spiritual and temporal, and the commons, otherwise known as Parliament. So Parliament being now assembled in a full and free representative of this nation, taking into their most serious consideration the best means for attaining the ends aforesaid, do in the first place, as their ancestors in like case have usually done, for the vindicating and asserting their ancient rights and liberties, declare. They're saying we're going to do just like our ancestors did in 1215. So we know that that was almost 500 years ago at that point, right? Yeah, almost. And we are going to, just as they did, we are going to reassert our rights and declare them, and here they are. That the pretended power of suspending the laws or the execution of laws by royal authority without consent of Parliament is illegal. We're declaring. That the pretended power is assumed. It's illegal. When you pretend it, it's not really yours. So the pretended power of dispensing with laws or the execution of laws by regal authority, as it has been assumed and exercised of late, is illegal. That the commission for erecting the late Court of Commissioners for Ecclesiastical Causes is illegal and pernicious. Levying money. All those complaints that they had, they go through the whole thing. It's number 6, right? Raising or keeping a standing army within the kingdom in time of peace, unless it's with the consent of Parliament, is against the law. The subjects, I would highlight this, the subjects, which are Protestants, may have arms for their defense, suitable to their conditions, and as always, and as allowed by law. The election of members of Parliament ought to be free. Don't mess with our elections. The freedom of speech and debates or proceedings in Parliament should not be impeached or questioned in any court or place out of Parliament. Parliament controls its own meetings. Excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Guys, again, I would highlight this because you're going to see these exact same words appear later in your American documents. Jurors ought to be duly impaneled and returned, and jurors which pass upon men in trials for high treason must be freeholders, landowners. All grants and promises of fines and forfeitures of particular persons before conviction are illegal and void. You can't take their property before they've even been convicted of the crime. No fines, no seizing of property before the trial. And that for redress of all grievances, for the amending and strengthening and preserving of the laws, parliaments ought to be held frequently. You may not prevent Parliament from meeting regularly. They must. Now watch this language. And they, meaning Parliament, do claim, demand, and insist. This is no longer a petition where we most humbly implore our great sovereign such and such. I want you to get a sense of the difference in the language. So I would highlight that too, because they've had it, guys. They fought a civil war. They've had 11 years of interregnum. They bring back the monarch, and he acts like a tyrant again, having not learned his lesson, drags him through the mud, drags him through wars, and finally now we have what we think are going to be monarchs that will protect the rights, liberties, and religious faith of the English people, protect the Protestant faith that's under such attack. And they are going to be very clear. We do claim, demand, and insist. So not a petition. This is strong, firm language. We insist on all and singular the premises as their undoubted rights and liberties. Those things we've just listed are our undoubted rights and liberties. The English Bill of Rights was designed to restore English liberties and to specifically clarify many points of the common law. The slogan of King William III, it was featured on his flag. It was featured in paintings. I was trying to find a painting. There's one at the Jamestown Settlement, an original painting at Jamestown Settlement of King William III. And up in the left-hand corner, it has his slogan, "The liberties of England and the Protestant religion I will maintain." That was his promise to the English people. I will be a different kind of king. And he was. He and Mary also signed the Act of Toleration of 1689. So not only the Bill of Rights, but now the Act of Toleration. And so, of course, William and Mary, go on your blank. This Act of Parliament, signed by William and Mary, finally recognized that with changing monarchs, every time we change the king or the queen as whoever is now the head of the Church of England, it's becoming highly, even if they make reforms, they recognize that, 2 generations from now, that the Church of England may swing back the other direction. So they recognize it's unlikely that true lasting reform, such as had been really suggested by the Westminster Confession of Faith, would ever remain in the state church, that it was likely to drift with the politician of the day. So rather than continuing to have that fight, this act simply granted liberty of conscience to non-conforming Protestant groups. Groups that felt like the Church of England had not gone far enough were now allowed legally to meet separately. It excluded Catholics, so it only applied to Protestant groups. Catholics were still considered to be a mortal enemy to England and to English liberty, because of the methods that they used to enforce their doctrine. So this applied to nonconformist Protestant groups who could now assemble, could form churches, could have their own preachers and their own church government. They had to be licensed. They had to swear an oath of allegiance to the monarch, and then they could worship according to their conscience. This was much more in line with biblical ideas about how the church should work. So in the New Testament church, for example, we see that it's a confession of faith that made you a member of the church rather than just being born as a Hebrew. Okay, so a confession of faith made you a member of the church rather than just being born in that nation. And that brings us to 2 of our founding thinkers that I want to introduce you to today. So the first is named Charles de Montesquieu, and you may have guessed he's not English. So I would write in the margin, or write in next to his name, he's French. And what's so fascinating about him, though, is that he looks across the English Channel. He's observing what's going on in England, and you notice what year he's born, 1689, dying in 1755. So guys, in 1689, who's just come to the throne? William and Mary. And he's going to live through William and Mary and Queen Anne and George I and into the reign of George II. So we have a lot to write here. William and Mary, he's born during their reign, lives through Anne, George I, and George II. And I would call these the glory days, perhaps, of England, at least as compared to what had just come before. So we have relative peace, prosperity, colonial peace with the colonies. Colonies are growing and doing well, prospering, and that's what he's observing. He's getting to observe, guys, the fruit of the fight to defend liberties. So what the parliamentarians, the Puritans in Parliament who stood up against Charles I and tried him for treason and took off his head, that same group that's reading John Locke, that is standing by Samuel Rutherford, that is reading Algernon Sidney, that same group is now going to hold, eventually, James II to the standard of English rights, right? And say, we're not going to let you get away with this anymore. And now they've established very firmly the rights of Englishmen and how parliaments to operate and how the representative system will work and what the accountability is of the king, and all of that has been solidified once again. So Montesquieu's looking across the English Channel and he's seeing, well, this is really different than what we've got going on here in France. Really different, because we have absolute kings. This is the time of Louis XIV, 15th, and 16th. We have kings who, it's part of the very doctrine that they are divine right of kings. Absolutely, they think they are the sun. They see themselves as the sun, the center of the galaxy. Anyway, so something very different is unfolding in England, and he's very curious about it, and he wants to study, why is it that English society looks so different? Why is it that the rights of English people are preserved in such a different way than the people of France? So, born near the end of Locke's and Sidney's life. So, John Locke and Sidney, he is that next generation of thinker. born near the end of Locke's life and at the beginning of the reign of William and Mary. He's writing during the 1740s and the 1750s. That's when he really comes into prominence. I would write in your margin. That's the time of the Great Awakening in America. He's writing, and his stuff's going to start to flow into the colonies and be widely read by your founding generation. Your founding generation are teenagers during the Great Awakening. So spiritually, there is something major that's happening to them and that they're observing. And at the same time, more of these writings are flowing into the American colonies, and they're reading them. Charles de Montesquieu is a strong Christian, a biblically rooted philosopher, and we're going to see it in his writings. That is what is feeding into the brains of George Mason and James Madison and Patrick Henry and so many of that founding generation. So it is providential timing because it is just before independence that he's writing. Now, he's French, but he's fascinated with English law and notes that there's a huge difference between the two. I've given you this little illustration where, once again, we're thinking root to fruit. What he saw in France was that the root was that the law is what lawmakers or the emperor say it is. That those that are highest in authority change the law to fit whatever the new understanding is of truth or morality. So the law could shift endlessly. And guys, we talked about that in some of the first weeks of our class, that we can, it's the two extremes of the teeter-totter. The little Latin phrase I put there was vox populi, vox Dei. And translated, that means, you might want to write, the voice of the people is the voice of God. That is scary. Because why? If we listen to the voice of the people, then we have everybody doing what's right in their own eyes. We have the tyranny of the 51%. You have pure democracy and you have anarchy. When there's no fixed standard of what the law should be and how it's rooted. So that's one end of the teeter-totter. At the same time, you have the opposite end. And if the law is whatever the king says it is, you have an equal opportunity for a sinful man to come to power and to abuse his people, which again, that's the rule. That's what normally happens throughout all of history. So that's what he saw as the root of French law, because it was rooted itself in Roman law, where the emperor declared what was right, or sometimes the emperor and a corrupt senate, or just a corrupt senate that wasn't truly representative of the people, but that what they said was law. Well, that Roman system, when the Romans occupied Europe, when the Roman Empire was at its peak, the Romans also had occupied Britannia. But guys, something amazing happened when the Romans pulled out of those areas and retreated back to the boundaries right around Rome. Across Europe, the Roman system of law was largely retained. In most places, that was better, I suppose, than what they had had before. So they retained Roman systems of law that were rooted in law is whatever the lawmakers say, or law is what the king says. Rex, lex. The king is the law. But over in Britannia, by God's grace, there were different roots that had been planted. And again, through the providence of God, Alfred will bring the Alfredian code rooted in biblical law, so they've got something different. So they have a law in England that's an unchanging law, given by God at creation, written on the hearts of men. It is unchanging truth, but it's just applied to changing circumstances, like we talked about earlier. Stealing is wrong. That's the foundational principle that we find in Scripture. In Deuteronomy, we see it explained and applied to the culture of the time. In English common law, you start to see that same principle applied to, you can't take, we won't take wood for our castles, we won't take your carts or your horses or your corn or your other movable goods. So the language changes, but the principle is the same. And that's where English law is rooted, in that unchanging standard. Guys, there are people today that say, oh, well, we have to be on this side. Law has to be changing and evolving because, after all, like the biblical law didn't confront things like the internet or transgenderism. Guys, the same principles apply. Scripture tells us there is nothing new under the sun. So when we examine, well, then how are we to handle this new technology of the internet? Well, principles about honesty and justice would be applied to the new technology. And transgenderism, we simply have to look at what does God say about who we are and who is in control of our identity. How did he create us, male and female? He created them. So there are principles within Scripture that speak to every issue. Do not let people talk you into, oh, we have to have an ever-evolving and changing law. No, you need to be rooted in an unchanging standard. It is the only sure ground on which we can stand. I remember vividly when I really grasped that concept years ago, that like if we don't know what we're rooted in, then how can we ever know, what's right, what's wrong today and tomorrow? It can shift on a dime, and that's no way to live. All right, I digress. In his most famous work, Montesquieu published this in 1748, and it is called The Spirit of the Laws. And in his Spirit of the Laws, he wrote this, and y'all bear with me. I'm going to take you through some difficult language, and then we're going to parse it apart. He said, laws are the necessary relations arising from the nature of things. In this sense, all beings have their laws. The deity, his laws. The material world, its laws. The intelligences superior to man, their laws. The beasts, their laws. Man, his laws. They who assert that a blind fatality produced the various effects we behold in this world talk very absurdly. Can anything be more unreasonable than to pretend that a blind fatality could be productive of intelligent beings? There is then a prime reason. And laws are the relations subsisting between it and different beings and the relations of these to one another. You're going to feel so smart when you break this down with me. Ready? So he starts with this, guys. Montesquieu says laws are the necessary relations arising from the nature of things. Laws are necessary. They have to be. He says everything that's created, and the Creator himself, have laws that are attached to them. Does God have law that's attached to? Are there things that he can never violate? Yes. He is always omnipotent. He can't not be omnipotent. He is omnipresent. He is always just. He is always holy. He cannot lie. There are laws that are attached to his being. Does the material world have laws that govern it? Well, clearly, if we just think about science for a minute, we have the laws of gravity and of motion and of phototropism. We know how cells divide, and they follow a law. There's a law of nature that's in place that they follow. Phototropism, by the way, is when a plant moves towards a light source. So it's following a law of nature when it does that. It's not just random. So there's law that's attached to nature. He talks about the intelligences that are superior to man that have their laws. And I didn't dig into that, but I'm assuming he means angels. We know that beasts, right? Animals, that there are laws about how they reproduce and how, there's law that is attached to their instinctual behavior, what they do, how their bodies work, all of that. There's law that's attached to that, and man has his laws. So let's, I think, break down a couple blanks. Is this the next thing I did? Okay, yeah, so let's go here. He says, now, those who assert that a blind fatality produced the various effects that we behold in the world talks absurdly. Guys, this is 1748. We are exactly 100 years before Darwin starts talking about the theory of evolution, that all things came from nothing and chance. And yet Montesquieu jumps in there and preempts him with an argument 100 years prior and says, anybody that thinks that chance, blind fatality, you can write words in if you need to help yourself remember later, those who assert that chance produced all the effects that we behold in this world talk very absurdly. Can anything be more unreasonable than to pretend that chance, blind fatality, could produce intelligent beings? So right here, Montesquieu asserts that none of this, what we see around us in the material world and in men, is an intelligent design, that there is providence. He says there is then a prime reason. So guys, when he says a prime reason, he's saying that Underneath everything you see, there is a primary cause, and that primary cause is God. When I talk about primary cause in history, for example, we talk about treaties that have emerged, that have resulted in certain boundaries for a nation. And God is the primary cause of that treaty. God is sovereign over all of it. Now, clearly, God does not, invent a treaty and just poof it into place, and there it is. No, men are used, God guiding their hearts and minds and placing people in the right place at the right time to bring about the result of that treaty. But the underlying primary cause, the omnipotent presence, is God. He is the prime reason. Okay, so when Montesquieu talks about a prime reason, he's talking about God. There is a prime reason, and laws are the relations, the relationship, subsisting. Subsisting means you exist in dependence on. Okay, so laws are the relation that exist in dependence on and between it, meaning God, and different beings. Laws are the relationship that govern how God relates to nature, how God relates to man. Then he says, between it and different beings and the relation of these beings to one another. So the prime reason is God. Laws are the relations that exist in dependence between God and the different beings and between the beings to one another. So there are laws that govern us this way, God to man, and there are laws that govern man to man. I hope you feel smart. I hope I explained it well enough. If he simplifies it a bit here, he goes on to write, God is related to the universe as its creator and preserver. The laws by which he created all those things are those by which he preserves them. He relates to his creation through laws of gravity. He relates to his creation of you through laws that he's given us, and you relate to other human beings through laws that he's established. So he is the prime reason behind those necessary laws. All right, all of that to say, Montesquieu is saying to us that laws are necessary, that the source of law is God, that laws regulate our relationships with him, with his created world, and with other people. And Montesquieu is telling us that the purpose of the law is for our good, for man's preservation. The laws by which he created all things are those by which he preserves them. Don't ignore God's law. It's what holds us together. Voltaire was another French philosopher who lived at the same time that Montesquieu did. And Voltaire is about the opposite of Montesquieu. So Voltaire was a humanistic, atheistic philosopher. He rejected all organized religion and in fact contributed greatly to bloodshed and chaos in France that's coming with the French Revolution. But at the same time, you guys, that's why I put this quote in here, because Voltaire read Montesquieu and recognized truth. He couldn't deny it. He said, the human family had lost its title deeds. Montesquieu found them and restored them to their owner. Guys, this is from a man who rejects organized religion, who in many ways hated God, and yet recognized that without God, when he says title deeds, a title to a car, a title to a home, is its ownership papers. And he said the human family had lost its title deeds, but Montesquieu found them, and he said, you were created by a God who also gave you laws that would preserve you. Montesquieu found the title deeds and restored them to their owner. Montesquieu was convinced that because God rules the universe by unchangeable laws, that civil governments should be ruled by law that was rooted in God's unchanging law rather than by men. So one of his great contributions, again, is the elevation of law over man's, law rooted in unchanging biblical law over man's ideas. Montesquieu also recognized another age-old truth. So he looked back to Isaiah 33:22, in which Isaiah wrote, "The Lord is our judge, the Lord is our lawgiver, the Lord is our king. He will save us." So guys, that's an idea that at this point is more than 2,000 years old. No, 3,000. More than 3,000 years old at this point. The Lord is our judge, the Lord is our lawgiver, the Lord is our king. He will save us. But Montesquieu looked at that and said, as so many had before, he recognized that these were the three types of power that you find in every government. There are the three functions. We talked about your conscience, right, being the seat of self-government, that you legislate. You have to have a standard of what's right and wrong. So you legislate for yourself what's right and wrong. You act, and then you immediately evaluate your own actions. You judge. So your conscience is the seat of self-government, and it legislates, it executes, and it judges. Well, he looked at this and said, look, every government does these three functions, and God could do it perfectly. So he takes a biblical worldview about who man is, and he expresses this idea. He said, in every government, there are three sorts of power. They are judicial and legislative and executive, just like we see in Isaiah 33:22. Judge, lawgiver, king. But only God, he then posits, only God can do all three functions perfectly and hold all three powers and use them justly and perfectly. When man, who is sinful, holds those powers, so let's now look at civil government as he is. So when civil government is formed and a man is holding all three of those powers, we could wind up in trouble because man has a fallen nature. So Montesquieu extended his biblical worldview to that idea and said, look, when the legislative and the executive are united in the same person, there can be no liberty. Y'all follow? You don't want the lawmaker to also be the one that's executing the law, nor do you want the one who's executing the law to be making it up. Here's what he said: the same monarch or senate may enact tyrannical laws and then execute them in a tyrannical manner. I would like you to write off in the margin, executive orders. This is why in America today we need to be really careful, because that is the executive branch or the president using his phone and his pen, as a former president famously said, but using that I have my phone and my pen. And so I'll just, if I can't get it done through Congress, I'll just write what I want and then it becomes a law. Well, we want to be really careful. The executive order was designed to be used in a very limited fashion. And today we have abuse of that power. At the same time, we want to be really careful that Congress isn't executing law, okay? Because you have the same problem. Then he goes on to talk about when we combine other branches. There's no liberty, he says, if the judiciary power isn't separated from the legislative and executive, because the life and liberty of the subject would be exposed to arbitrary control if the judge is also the legislator. We want the judges to not be making law, because then who is there to check them? Who is there to decide that that doesn't match up with our Constitution, for example? We don't want, you may have heard conversations about judges legislating from the bench, making law. And there's a big debate about why that's happening, that our legislative body, Congress, is passing the buck, that they don't want to legislate because they don't want to be unpopular. And so they'd rather have people bring court cases and have judges rule on things they really shouldn't be ruling on, that then set in place a standard that's recognized as law. I digress a little bit. I know that's a big, deep idea, but get this, you guys. Essentially, he's just saying we need to be very careful that these three powers are separated and that they do not transgress on one another's jurisdictions, that the judges are only judging, that the legislators are only making the law, and that the executives are executing the laws, and that they don't combine those things. So what he's proposing is the separation of powers. He wrote extensively about who should serve in each branch and how they should be chosen, which I'm sure you don't want to necessarily go in and read this. I'll post these pages to our website in case you do. But he also wrote that one great fault there was in most of the ancient republics, he said, and that was that the people had a right to active resolutions. So get what he's saying. When he says they have a right to active resolutions, he means that they're voting on every policy. He's talking about direct democracy. He's talking about ancient Greece. So when he calls it an ancient republic, he means ancient Greece. And the problem was that the people had a right to actively participate in every decision. He says that was a thing of which they are absolutely incapable. That's right. That's the tyranny of the 51%. And guys, I know that's not popular in conversations with your friends on a college campus to say that you're not capable, but it's true. Most of us don't have the knowledge. Most of us don't have the character. That is why we have been, our founders said, look, if they'll just choose wise men to rule over them, this thing has a shot at surviving. But we've learned from the example of history that, again, when people all have that right to active resolution or voting on every law, that we get a tyranny of the 51%, that the people as a mass don't tend to be wise enough to effect good government. So they're better, he says, they ought to have no share in the government, but for choosing of representatives. So he's certainly very much in favor of voluntary consent through representatives. So making his case. And then he says something even more controversial. In a country of liberty, it is fit that the people should transact by their representatives what they cannot, not more controversial, but they should transact by their representatives what they cannot transact by themselves. So again, he's advocating for a representative form of government. It's a warning against pure democracy. It's an endorsement of representation and locally choosing wise men to rule over you. Remember again, he had traveled in England. He had observed their system. He had seen the shire system, the tithings, how they had locally chosen representatives that were serving them within the parliamentary system. And that brings us finally to William Blackstone. So Blackstone comes a little later, and Blackstone, if you look back at your bookmark and see when he's alive, he's going to be alive during the Great Awakening, during the American War for Independence. He's born during the reign of George I, lives through George II, and into George III. So he's even the next generation from Montesquieu, living during the Great Awakening and the American Revolution. Now Blackstone becomes known as kind of the new Sir Edward Coke. Y'all remember Sir Edward Coke, who stood up against the king, stood up firmly against King James I and said that, the common law is made up of 3 parts, but the king's proclamation is none of them, and had to also stand up against Charles I, was willing to go to the Tower, wrote his institutes, institutes on the English common law. So this guy is the new version of Sir Edward Coke. William Blackstone will write a series of books on the common law, improving on and organizing the works of Coke. And he published his, I'm sorry, that's the wrong word, it's commentaries. I got mixed up there. So Blackstone wrote his commentaries on the laws of England. Coke wrote the institutes. So Blackstone will publish his commentaries on the laws of England over a 4-year period starting in 1765. Guys, 1765 is a significant year in America because that is the year of the Stamp Act. This is a year when the first kind of pushback against English tyranny begins. So it's really important and providential that Blackstone is publishing right at the time that the American people need it. So in his commentaries, he gives detailed explanations about how English law worked. He's looking back, and he's bringing all of these themes forward and telling how this applies today, which I know we've talked about already, so I won't again. He's looking at Magna Carta, Petition of Right, the English Bill of Rights, the Habeas Corpus Act, and so on and so forth. And he's parsing them and helping lawyers understand how they're applied to English law today. Also, some of you have asked why I sometimes put charta and sometimes no H, and that's because it's proper either way, and I see it in my head. I learned it C-H-A-R-T-A, so I sometimes fall back on that and forget to become consistent with Magna C-A-R-T-A. All right, here's some of Blackstone's thoughts. Blackstone defends the idea that God, again, is the source of the law, just like Montesquieu had said. He says, and this is so clear, he says, this law of nature, when we look out, in fact, he says it a little more clearly than Montesquieu, which should make you happy. So this law of nature, dictated by God himself, is of course superior in obligation to any other. This law, God's law, it's binding over all the globe, in all countries and at all times. No human laws are of any validity if they're contrary to this. No human law is of any validity if it is contrary to God's law. I vote that we inscribe that on the walls of Congress in Washington, D.C. How about that? So this should, of course, sound familiar to you. Blackstone's writing it in 1765. Montesquieu had printed it in 1748 in Spirit of the Laws. And Samuel Rutherford had said it. This was in our notes last week. So right here on the back page, right down here, Rutherford's title, Lex Rex, implied that the king and the people, that both the king and the people had certain rights, but that both must be just or conform exactly to God's law. Here's what Rutherford said. God has appointed kings as agents and servants of his law for the good of the people, and thus when kings act contrary to God's law and the good of the people, they may be resisted. So again, the root of true law is God. It also echoes what John Calvin had said back in 1536. If God is the sole lawgiver, men are not permitted to usurp this honor. Men can't just make up what they want. We should be able with ease to distinguish what human constitutions are contrary to the Lord's word. Well, that might be another. Actually, all three of those quotes would be great ones to inscribe upon the walls of our Capitol building in Washington, D.C. Along with the Deuteronomy 17, 18 through 20, that he shall make for himself a copy of this law and keep it with him and not turn from to the left or the right and not think himself above his brethren. That would be another great one to put on the walls. All right. Blackstone's commentaries, you guys, they become the most important law books that are studied by that first generation of American lawyers. These are young men who are coming of age during the years just before the American Revolution. So they are studying Blackstone's commentaries in their law schools. The first law school was actually at William and Mary. Law schools are just really being established in the colonies. And in fact, what's interesting is a lot of the more prominent families in the colonies, if they wanted their sons to be lawyers, they would still send them back to England and they would study at the Inns of the Court in London and then return to the colonies to practice. But so interesting, there was such a hunger for this information that special printings of Blackstone's commentaries had to be produced. There was such a huge demand in the colonies for these that special printings were made, and many, many, many hundreds of copies were shipped into the colonies so that people could have access to this new information. Now, from Blackstone's commentaries, American scholars have in their hands for the first time a well-documented inventory of English law showing the unchanging source of the law and the connections between the various parts of the law and the biblical reason for the law. Blackstone is a firmly rooted Christian, and we see it expressed throughout his commentaries. And you can't help it. If he is expositing English law, you can't help but reflect its source, which was biblical law. And this is a quote from a wonderful book that I have by Guy Ferdon, where she says that this book couldn't have come at a more providential time, or these volumes couldn't have come at a better time, because it was just at the time when the need for a unified system, both in law and politics, was beginning to be felt in the colonies. Nearly as many copies of Blackstone were sold in the backwards American colonies. Again, that's why people sent their kids over to the Inns of the Court in London, is that some folks still looked down on the law schools that were in the colonies and thought them inferior. And yet, you guys, nearly as many copies of Blackstone would be sold here as would be in Britain. The best sellers during this time frame in America were Bibles and law books and sermons. So I'm just saying, there's probably something to that. What are we soaking our brains in? And what's going to be the result of what we're soaking our brains in? So they were very serious about studying and knowing these truths and preserving their liberties by knowing those truths. Okay, you guys, that should be, almost the end. Last little chart that I wanted to show you in our note sheets this week. I'm going to return to this in future weeks, but you should know that a lot of people will say that the founding of America was rooted in the French Enlightenment. I guarantee you when you go off to college, you're going to hear that. Here's the French Enlightenment, just in case you're looking, all right? But yet, there are scholars who have parsed apart, who've diced apart the writings of our founding generation. And what do they find when they look? When they actually go line by line and say, where did that come from? Kind of like we did earlier when we looked at the English Bill of Rights and said, well, where did that idea come from? And we can trace it right back to Magna Carta or Petition of Right. Okay. Well, there are scholars who have done that with the writings of our American politicians. They've read John Adams and John Jay and James Madison and Samuel Adams, whatever. They've read all these guys and started compiling, looking line by line, where did that idea come from? And tracing it back, because these are not their own thoughts. They come from pulling books off, they've read extensively, they've digested these things, and now they're expressing them in their own words. But where did the ideas come from? Well, what they find in this extensive study, it's published in a book by Don Lutz, The Relative Influence of European Writers on Late 18th Century American Political Thought. So in that study, what they found was that 34% of all material cited by American political writers came directly from the Bible. That is the source. That they're quoting a Bible story, a biblical anecdote, biblical law, something. 34%, you guys, comes right from the Bible. Tied at 34%, they're quoting or deriving their idea directly from the Whigs and the first wave of Enlightenment philosophers. Who are those when they say that? First wave? The first wave of Enlightenment are not atheistic humanist Frenchmen. They're biblically based Englishmen. The first wave, if you want to call them that. So that's Algernon Sidney, it's Montesquieu, it's John Locke, and it's Pufendorf. I know we didn't introduce Pufendorf. We won't this year. Okay, but just know he's another biblical thinker. So 34% are quoting, 34% of the material is coming right from these biblical political philosophers. 11% is coming from Blackstone and Cook, who are law scholars. But guys, you just read some quotes from them. It's all rooted in a thoroughly biblical worldview. Then we go to classical sources like Socrates, Plato, etc. Some peers, they'll be quoting some of their peers or other sources. But again, I would almost guarantee you that many of their peers also have a strong biblical worldview from which they're quoting. And then finally, at 6%, are those French Enlightenment thinkers like Voltaire and Rousseau. So guys, let's add up just these top three where we know that these guys are solidly biblical in their foundations. And we come up with 79%. I didn't fill in that blank, so you can, but 79% of all of the source of their information is coming from a biblical worldview. And only 6% can we definitively say is coming from French Enlightenment sources. So that's really important to recognize. The other important source is who are they citing? Who are the most cited thinkers of all? So interestingly, Montesquieu runs away with it, 8.3, along with Blackstone. So Montesquieu and Blackstone are the most influential, and they're writing in closest proximity, right, to their contemporaries of the founders. So they're reading them and they're quoting them frequently, Montesquieu and Blackstone. Then Locke, John Locke at 2.9%. Everybody else is down in the 1.5 to 1% range. That's important to recognize because you now have an understanding of who Montesquieu was, where his roots were, what he believed about God and the source of law, as well as Blackstone. So guys, this is solid scientific information that helps you stand up against theories that are promoted that are telling you that America came from a secular or an evil source. It did not. All right, I will leave it at that. Your homework for this week. Oh, nope, we're not quite done. I'm so sorry, you guys. Okay, let me finish up. Our last bit of historical context. That's right, before we get into your homework. So from 1702 to 1760, moving forward now, English monarchs are being preoccupied with wars, and the colonies are able to be largely left alone. And so they get like 58 years of just self-government. Nobody's messing with them. And this practice of non-interference by the crown was called salutary neglect or healthy neglect. This will continue during the reigns of Queen Anne, King George I, King George II, but everything will change during King George III. So the British and French wind up going to war during they'd actually started the war during his father's reign in 1754. There was fighting in Europe between the British and the French, but it spilled over into the colonies where British and French land claims conflicted on the western side of English settlement. So out past the Appalachian Mountains, we began to see French and English butting up against each other. And the war in the colonies was called the French and Indian War. They called it the 7 Years' War back in Europe, but same countries. It'll end in 1763. The British win. In fact, the British will now gain even more colonial territory because East and West Florida were actually ceded in the treaty that ended the French and Indian War. It was called the Treaty of Paris. And in the Treaty of Paris, the Spanish were forced to give up their holdings. That's because the Spanish had sided with the French in the war. So now the Spanish were forced to hand over East and West Florida to England. So we now have 2 Floridas becoming the 14th and 15th English colonies. Guys, nobody ever talks about them. That's because they're going to stay loyal. They will not sign off on the Declaration of Independence in the future, but they are English colonies. And here they are. East Florida, West Florida are joining Georgia as English colonies for about 20 years. They're English colonies. Now, the British have achieved a victory, but the war left their finances severely depleted. And so in the years that followed, the government under King George III and his parliament try to squeeze out every little shilling that they can from the colonies. They are asserting more and more direct control over the colonies. They are doing things like regulating how and with whom the colonies can trade. They're trying to do this to force them to trade directly with the mother country. They don't want them giving trade to France and Spain, or, and they may be able to get a better deal there, but they're forbidding them from trading with these other countries. It's helping England financially, but in many cases it is very negatively impacting the colonists. They begin to impose taxes that are passed by Parliament back in London and not by local assemblies. They are refusing to allow Western migration into territories that were given to these colonies in their charters. And now there was the proclamation of 1763 that's saying, no, I don't want you. George III does not want anybody moving out past the Appalachians. And he says that's because we don't have the military to protect you. But the colonists largely think that it's because he wants them under his control. He wants to keep them in areas where the tax collectors can get to them. The king is refusing to sign legislation that's passed by those House of Burgesses, the town meetings, the other colonial assemblies. He refuses to sign off on their laws, and so they are unable to put them into effect, and it's damaging their ability to govern themselves. He starts using his royal governors to dissolve their town meetings or their local assemblies if they dare to discuss any violations of their rights as Englishmen. And he starts to bring thousands of British regular troops into the colonies, even though there's no war going on. That should ring a bell, right? He's really doing it to support his royal authorities and to show force and to intimidate the colonists into obedience. When the colonists began to resist, the king began to also interfere in their judicial system. He begins appointing the judges that he wants, and he takes over payment of their salaries, which sounds like, isn't that nice? Except now these judges answer directly to the king, and so they're much more likely to rule according to his will rather than answering to a local body of people that have chosen them. He begins taking accused persons, people that are accused of breaking some of these new tax laws and trade laws, etc., out of the colonies. They're being tried in military courts. Should ring a bell, right? And begins sending more troops and forcing some colonists, particularly the Bostonians, to quarter or house the troops. After 140 years of self-government, these abuses of their rights as Englishmen, of course, shock the colonists, because we've had generation after generation after generation of freedom, of enjoying our ability to self-govern. So they responded as they should. Petitions began to be sent, resolutions were passed objecting to these abuses, but particularly from 1765, which is the first year that Blackstone's commentaries appear in America. From that point, there's also a law that's passed in Parliament that impacts the colonies. It's called the Stamp Act. So 1765 is a banner year in American history. From 1765 until 1774, that 9-year period, there's petitions, there's resolutions, but overall things are spiraling downward, they're deteriorating. And eventually the colonies will recognize that the only way they think they have a way out of this is to come together, to work together, to continue the process of biblical resistance, beginning with petitioning the king and his tyrannical government. Now, I had to give you that background because you need it for your homework. I'll give you just a little bit of introduction on each one of 2 documents that you're going to be looking at. One is the Stamp Act Resolves, and then 9 years later, that was in 1765, like you see right here. That was kind of the first shot from the English tyrant King George III. So we're going to see how Patrick Henry responds to the Stamp Act with his Stamp Act Resolves. What issues is he raising? And they should, again, sound familiar to you. So the first shot was kind of in 1765, and then in 1774, you have another document to read called the Suffolk Resolves. And we're going to look into that document and see what are some of the issues that these folks from Massachusetts, Suffolk, Massachusetts, what are the issues that they're raising? What are the problems that they see with how the king and parliament are behaving? So you're going to look at those 2 documents for your homework this week, and you're going to be kind of CSIing. I'll pop out certain sections, and we want to look for, where have I heard this before? How are they justifying their demand for their rights as Englishmen? Where do they get that idea? All right, you guys, that's it for this week. So I hope you have a great week, and I look forward to seeing you for week 10 when we'll quickly review what you found in the Virginia Resolves and the Suffolk Resolves.